I thought I would introduce myself. I'm Kaaryn Gustufson. I teach law at the University of California, Irvine School of Law. I'm getting a weird sound here, so let me adjust. And I'm going to talk a little bit about debt. My talk is titled Perpetual Debt and Quiet Legacies of Servitude. I don't know what's producing feedback. But it's often said that to be American is to be in debt, and that is truer now than ever. According to the Federal Reserve, outstanding consumer debt. Okay. Outstanding consumer debt in the United States for November 2016 was $3.75 trillion. That does not include mortgage debt. That's just consumer debt, student loans, auto loans. In the last several decades, we've seen a number of economic shifts, including stagnating wages for the middle class, declining wages for those at the lower end of the earning scale, plummeting savings, and the unraveling of the safety net. And so the way consumption has continued has largely been through consumer debt. So that is the backstory. Consumer debt has served to hide a lot of financial instability in the United States. And consumer debt used to be limited to people of middle-class means and better, but around the mid-90s, at the very same time that the federal government passed welfare reform legislation, which did away with cash benefits as an entitlement. Financial institutions also realized that they could make a lot of money on high-risk borrowers through high-interest lending and through fees. And so we've seen a huge growth in consumer debt, especially in areas that we hadn't seen before. So payday lending, right, high-interest payday lending. We have new forms of automobile loans emerging right now that are both high interest and that come with GPS devices that shut down the engine. So there's a lot of debt out there. But I'm going to talk a little bit more specifically about legal financial obligations and this other form of debt that creates problems for people and that often isn't measured when we're talking about debts that are being carried, in large part because these aren't debts that can be discharged through bankruptcy. So they tend to be ignored when we're talking about all of the debt Americans are carrying. So first I'm going to give an overview of some of the recent legal scholarship on state-imposed debt and some of the consequences of that debt. Second, I will talk a little bit about recent reform efforts, especially when it comes to criminal fines and fees. And third, I will frame some of these issues in a broader discussion of servitude. So in talking about the growth in criminal fines and fees over the last 30 years in particular, I think it's important to talk about misdemeanors. For those of us who teach criminal law courses, we tend to focus on felony offenses. And until recently, much of the policy analysis of the criminal justice system has focused on felony offenses. In the last few years, however, scholars have urged greater attention to misdemeanor crimes, arguing that they make up the vast majority of criminal charges and convictions, and that the resolutions of those cases have broader negative effects on individuals and families than we've been documenting. Loyola Law School professor Alexandra Natapoff in 2012 published an article titled Misdemeanors, where she argued we've taken insufficient notice of the impact heavy misdemeanor fines have on people who are convicted. Misdemeanors affect housing, employment, and educational opportunities. They often result in incarceration for non-payment, and they carry a stigma that while is less of a mark than a felony conviction, it's a mark nonetheless. Natapoff also explains that in practice, right, on the ground, the pettier the misdemeanor offense, the less likely it is that due process and rule of law protections will apply. She argues that we've developed, quote, a high tolerance for wrongful petty convictions, unquote, and that this tolerance has racial implications. Along the same lines, Yale law professor Isa Kohler-Hausman has conducted an in-depth multi-method study of misdemeanor courts in New York. She writes that while misdemeanor arrests have more than doubled in the last 35 years, these rates don't reflect changes in crime trends. Instead, they reflect changes in police practices. She argues that misdemeanor courts are not about fact-finding, not about public safety, not about justice. Rather, they are about social control. Kohler-Hausman explains that the court officials who she interviewed, who engage in a lot of supervision of misdemeanor defendants, see their role as monitoring at-risk populations, right? Keeping a close supervisory role over this group of people. Let me talk a little bit about legal financial obligations and their growth. So recent scholarly research on legal financial obligations, both for criminal offenses and child support, has been particularly illuminating in the experiences of low-income individuals. A book I would recommend to you is Alexis Harris's 2016 book titled A Pound of Flesh, Monetary Sanctions as Punishment for the Poor. Harris puts forth a devastating critique of the expansion of criminal fees, the privatization of probationary supervision, and the efforts to extract payments from the poor. Some of the practices she describes, including imposing surcharges on defendants, charging fees for public defenders and for applications for public defenders, and incarcerating misdemeanor defendants for willful non-payment, are policies and practices in place in Kansas. Tanya Brito is doing a very detailed study of child support enforcement courts in the Midwest. She's published 2 pieces out of that study so far and expects to publish more. One of her pieces is titled, I Do for My Kids. And that's based on the observation she and her co-authors did in several child support enforcement courts. And she describes the atmosphere of those courts as degrading for the parents who are going through and again explaining why they can't pay their child support obligations. And many of the parents who return repeatedly are African American, they're men, they have convictions, often low-level convictions from their youths, and they have thin work histories. And so the combination of all of these things, right, the past convictions, the low education and limited work history, and their race makes it very hard for them to find a steady job. And so child support enforcement really ends up playing this ceremonial role more than anything particularly meaningful as far as extracting money from these parents. There's been some recent writing on excessive fines and fees that I'd like to point you to. Beth Colgan at UCLA has written several pieces on excessive fines and fees. In one of her articles, she does a very detailed analysis of the history of Eighth Amendment excessive fines and fees clause, and argues that the founders never saw fines and fees as something that would do away with a person's ability to make a living. And she says that where we are right now when it comes to the imposition of fines and fees is that we really are holding people down, that the debts people carry are not debts they can overcome. And she urges attorneys to push harder for waivers of fees when that's possible. There are also a couple scholars writing about the 13th Amendment and arguing that a lot of what we're seeing when it comes to the imposition of criminal fines and fees harkens back to earlier practices of debt peonage. Noah Zatz, a UCLA law professor, has written, published in 2016, a provocative article on debt peonage, where he says both child support enforcement and legal financial obligations should be considered to fall under 13th Amendment protections, and lawyers might do well to start pushing there. Which takes me to some of the work I've been doing recently. I'm writing a book on the history of bastardy laws, and you may be shaking your head thinking, what the heck does that have to do with all of this? But most people don't know a lot of the history on bastardy laws, and there was a racialized treatment of bastardy laws. So bastardy laws in northern states were civil claims that were brought against fathers. Liens could be taken out on their property to pay support obligations. But in slaveholding states, where marriage certificates were made very expensive, bastardy laws were criminal statutes. And they were used mainly against free people of color. Both mothers and fathers could be convicted of bastardy. If they could not pay the fines, then they were indentured. Usually it was the men who were indentured for 3 years upon fathering a child. And it also extended to children. So illegitimate children were forced into apprenticeships, even if they were living with both parents, even if their parents were providing support. They were put into apprenticeships at working age. Now, for white children, working age was age 12 or 14. For black children, working age began at around age 7. But I found many cases where it began even younger. I'm just now working on the later chapters of that book. But there are some correlates, I think, between what we see now in child support enforcement and things that were going on in the past. With bastardy laws, we see the same populations overrepresented, especially African American men. Reva Siegel, law professor at Yale, writes about persistence through transformation, that while laws and policies may change, the inequalities and injustices remain. When it comes to debt, particularly legally imposed debt, we see that persistence. We see similar correlates, I think, between debt peonage of the past and between some of the things that are going on with fines and fees today. Now, the Department of Justice, at least during the Obama administration, gave a lot of attention to fines and fees. The Ferguson report really put the spotlight on court-ordered fines and fees, and highlighted the use of fines and fees as a way of generating revenue for municipalities. The Department of Justice also issued a Dear Colleagues letter in 2014 urging state courts and local courts to be careful about their use of fines and fees, and noted that in jurisdiction where fines and fees were used to fund the courts themselves, there might be a conflict of interest. So I'm going to wrap up just by noting that we tend to think of courts as neutral institutions when it comes to debt. That courts are simply institutions that allow rational actors to resolve their rationally agreed upon or rationally imposed financial obligations. But what we're seeing is that law is not necessarily neutral, right? And when it comes to debt obligations, courts tend to be extractive. They're extractive in ways that reinforce social, economic, and racial inequalities. And I will leave it at that for now. But I will take questions and comments before we move on to Chuck's presentation. If there are any. Mm-hmm.
At least in Kansas, the state can create a lien, differential wages, et cetera. Have you looked at all?
I haven't focused on unemployment, I have to say, but a lot of these fines and fees, if they go unpaid, across the country, can create huge interest burdens for those who owe legal obligations. And Alexis Harris offers the example of a woman who was arrested for prostitution several times and had $35,000 in fines and fees imposed. And because of her inability to pay, that had doubled to $70,000, at which point it was something she simply couldn't pay, and it was preventing her from entering the mainstream labor market, and it was also preventing her from getting married. That these debts are also affecting family formation. Yes.
Have you drawn any conclusions about what you described as apprenticeship? How it compares to the impact of what the courts are doing today with young people? You understand my question?
With community service or with?
Well, whatever it is. I mean, have you seen a modern-day version of apprenticeship based upon your research? Where is it?
Excuse me, I have a terrible cold. So Noah Zatz at UCLA argues that even community service looks a lot like debt peonage, that people are laboring for the state and not drawing any wages, and that harkens back to older forms of servitude. My work hasn't explored that so much, but there may be some corollaries.
Yeah. Do you reject the notion that
I don't reject community service, and if people are able to do community service instead of pay fines or fees, and that works for them, I think that's great. I think it becomes a little bit more problematic when community service is preventing people from engaging in paid work.
Hello, everybody. My name is Chuck Epp. I'm a professor in the School of Public Affairs at the University of Kansas. I'm a political scientist there. And what I would like to do is to pick up and build on a point that Professor Gustufson made partway through her talk about how changes in police practices have implications for this real growth in misdemeanor charges and also for racial disparities in those charges and all the consequences that go along with that, including such things as jailing and longer-term imprisonment for those arrests or growing out of those arrests. What I have to say is based on a study that two colleagues of mine, Stephen Maynard-Moody and Don Heider-Markel, and I carried out over the past 10 years. And we published it in this book, Pulled Over. It's about racial disparities in police stops. And what I'd like to do, I want to do this pretty briskly so that there's time for question and response to what I have to say here. So I'm just going to give you the briefest sort of nutshell version of this and then some snapshot pictures to illustrate what we found. When we started looking at the problem of racial disparities in police stops a little over 10 years ago, we became convinced that most of the studies on this question were getting at it in a wrong kind of way. By and large, they rely on, and they still do, on official, what we call COP data, administrative data based on traffic citations. So you get a ticket that's entered into a database. Across tens of thousands of those, scholars dig through it and see, are there disparities in who gets those tickets? At the time, we learned from one other study that it was likely that only about half of the stops made by officers yield some sort of written record, which means there's sort of a large hidden world of police stops that don't appear in administrative data and that thus don't form a part of these studies, a basis for these studies. And so we cast about and thought, well, how do you get at that hidden world? And the way we did it was to do a survey of drivers. We did this survey in the Kansas City metro area. It's based on a well-accepted social scientific model of how you measure experiences with crime, but we're here measuring not crime victimization, as is done by the National Institute of Justice, but contact with the police, if you will. Okay? So we asked 2,300 drivers in the Kansas City metro area whether they'd been stopped in the past year. And if they said yes, then we asked them a whole host of questions about their experiences in those stops. What was the stop for? What happened in the stop? What did the officer act like? How did the officer speak? What was the race of the officer? You know, anything that you might want to ask. We also asked about what kind of car do you drive? How do you drive? Things that speak to what's called the baseline question in these studies. That is, when you find disparities in who is stopped, the question always comes up, well, what do you compare that against? Maybe there are more black drivers on that street. You know, that's a baseline question. Maybe black drivers are speeding more on that street than white drivers. The baseline question has vexed scholars in this area. We ask people, how do you drive? What kind of car do you drive? Does your car have unrepaired accident damage? Do you have a taillight out? You know, all the sorts of things that would add up to speaking to this question of a baseline. Okay, so what did we find? In a nutshell, we were really quite surprised by what ends up being the core finding, the core thesis of the book. It may not surprise many of you as lawyers who perhaps work in this area, but it did us based on all the research in this area. We did not find that racial disparities in stops are scattered across a whole range of types of stops. That is, in speeding stops, in stop sign stops, in not signaling a lane change stop, and so forth. What we found instead was that stop patterns differ or cluster into two recognizable types. Those types appear in our statistical patterns, and I'll give you some indications of that in just a moment. And they also appear in the stories that drivers told us about their experiences in these stops. Two actually radically different stops that differ from start to finish in their character, in their purpose, in the experience of the driver, in the sanction that results in the end. Okay, so what are these? On the one hand are what we call standard traffic safety stops, where a driver is doing 10 or 15 over, and the officer stops them and says, hey buddy, you were going fast, I'm going to have to give you a ticket, and then processes that ticket and returns and lets the driver go pretty briskly, perhaps with an admonition to slow it down. So that's one type of stop. The character is all about sanctioning an observed traffic violation. The other type of stop is radically different. And I'll give you an example of how it proceeds, and then I'll tell you what it's all about. We call this an investigatory stop. It goes like this. Officer walks up. What are you doing in the neighborhood, ma'am? Where are you going? Oh, you going to work? Well, if you're going to work, you're probably not carrying a bag of drugs in the trunk, are you? No? Oh, well, then you wouldn't mind if I popped the trunk and took a look, would you? The second type of stop, again, we call it investigatory, is all about investigating the driver, sometimes out of nothing more than curiosity. Is this driver up to no good in a serious criminal kind of way? It's based on something that struck the officer as being odd or out of place. That driver doesn't seem to fit the vehicle, doesn't seem to fit the neighborhood. What is this person driving here for at 2 in the morning? Let's check them out. It's all about questions. It's often about trying to get into the vehicle, under the seats, into the trunk, and so forth, to find contraband or a gun or the like. That type of stop differs from the first from start to finish. It is not about sanctioning an observed violation. It typically does not end in a sanction. In fact, the vast majority of people stopped in that second type of stop are found with no problem, nothing on them, and are let go. And officers, we interviewed lots of officers as well, they think that in those kinds of situations, no harm done. No ticket, they shouldn't be terribly upset. I was polite. Most of the time, our data reveals they are professionally polite. Okay, now, not surprisingly, the subtext of all of this is we find basically no meaningful, statistically meaningful, or very small disparities by race in the first type of stop, but wide, dramatic, statistically significant, meaningful in every kind of way disparities by race in the second type of stop. All right? Let me give you some snapshots of this. Oh, I need to say, this is taken from a commonly used police training manual, the steps in an investigatory stop. I need to emphasize when I say changes in police practices, this is regarded by the police profession as a best practice in how one goes about fighting crime. It's trained, officers are directed to do this. At the end of the process, you see seek bonus benefits, forfeiture, take the vehicle or cash if you find it on them. Officers know this mantra, know this approach, they know the tricks of the trade, and they practice it all of the time. Again, to emphasize, it is regarded by the police profession as a best practice. It's been vetted by the federal courts, you may know, approved by the Supreme Court in a case from the mid-90s called Wren versus the United States. There's a large body of professional writing on this saying, do it well, direct your officers to do it, ensure that they maintain professional courtesy while doing it, but have them do it. All right, let's look at some patterns here. I'm going to show you, so as I said, we asked drivers to report stops to us, and then we ran statistical patterns on the most recent stop. It's a way of randomizing their experiences that they experienced. And we put these types of stops into these two buckets, traffic safety and investigatory, based on what the officer said upon walking up to the driver. What's the violation that they announced? Who is stopped by the police? In speeding stops, The pattern is quite striking. The more you speed, the more you are likely to be stopped in a traffic safety stop, in a speeding stop. There are some apparent differences by race and gender here, but those are not statistically significant. We're controlling for everything, by the way, here else that might matter. Type of car you drive, what do you look like? Do you wear a suit? Do you look like a doctor? Do you look like a professional athlete? We tried to get at street presentation. Do you commonly roll through stop signs? Do you signal lane changes all the time? All those sorts of things. Speeding is what gets you caught for speeding. Okay? What gets you stopped for investigatory stops? It's who you are. First and foremost, the thing that jumps out at our data all the time is race. Young black men are dramatically more likely to be stopped in these stops, investigatory stops, than anybody else. Young African American women next. Young white guys experience this at higher rates than young white women, but considerably less than African Americans. These are wildly statistically significant in our data. Those are very large disparities. African Americans are stopped at roughly 2.7, nearly 3 times the rate of whites in investigatory stops. I can do many things with this. Let me just draw your attention to one other thing. African American guys who are about 50 have the same likelihood of being stopped in this sort of a stop as a young white guy. All right? Now, what happens during stops? Speeding stops, mainly about giving you a ticket or letting you go with a warning. Racial disparities are not large and are, by and large, not statistically significant when you compare, when you control for other things. Not a lot of threats of arrest, vehicle search, driver search, and so forth. Okay? And the racial disparities in those things, in those intrusions, not great. Investigatory stops, sanctions, official sanctions, much less common. A whole lot of asking, what are you doing in the neighborhood? A lot of searches. In these stops, African Americans are 5 times more likely to be searched than whites. 5 times more likely to be searched than whites. That's a massive disparity. Dramatically less likely to be found carrying contraband or a gun. They're searching the wrong people. And that, by the way, is a pattern that's common across a number of other studies like this one. Is this experience common? I neglected to say this a moment ago when I described the patterns, but half of the stops reported to us by black drivers as the most recent stop that they'd experienced in the past year, half the stops were investigatory stops, have this character. Half the stops. Dramatically less common for white drivers. I want to wrap up quickly. In the book, if you're at all intrigued by this stuff, check out the book, pick it up or something. We have a long section on what now, for simple summaries purposes, I call the long-term harms of experience in these stops. People take lessons about the police from their experience of stops. People take lessons. People learn something. White drivers who mainly experience traffic safety stops learn that the police are basically fair. You're not going to get stopped unless you're doing something, pretty significant. And you'll then get a ticket, but that's basically because you were speeding. That's the lesson I used to always take when I was younger and got stopped. Chuck, you ought to slow it down. African Americans who commonly experience the other kind of stop learn the lesson that you can't trust the police. As one driver put it, you never know what a police officer is going to do. You never know what a police officer is going to do. So we have a whole, I don't know if you can read this at the back of the room, a lot of questions that speak to how much you trust the police. I'll break some of them out here quickly. To what extent do you think the police are out to get people like you? Very large disparity by race in yes answers to that question. Over 30% of young African American men say, yeah, I think the police are out to get people like me. Turns out that young white guys, about 17% of them say yes to that as well, but by the time they're 30, they no longer believe that. Their experiences have shifted. To what extent are you uncomfortable calling the police for help if you need it? Huge disparities by race in this as well. The one that I find, this is Kansas City, that I find especially poignant, painful, but powerful, is to what extent do you avoid driving in some areas of the city, this is Kansas City Metro, for fear of how the police may treat you? Over 2/3 of young African American men say yes to that question. Say yes to that question. Young white guys, about 38, 39% say yes as well. By the time they're 30, they feel free to drive everywhere again. But this, somewhere around 40% across the life course, African American guys are saying yes to that. When I'm speaking in public on this, and I do fairly commonly, I say, folks, what is this? This is almost like you have to, just to put a clear point on it, this is American-style apartheid. The old pass laws in apartheid where you couldn't go some places. This is the American version of that. And we find, I'm not giving you the statistical evidence of this here. If you're at all interested in the book, we show clearly that it's the experience of an investigatory stop that directly contributes to these perceptions about the police and about one's freedom in society. All right, so when Professor Gustufson talks about shifts in police practices that generate more misdemeanor arrests and for certain kinds of people and the cascading consequences of that, this is the practice, the practice of investigatory stops that is contributing to those patterns. There isn't an easy solution to how to deal with this. I'll simply say again, the police as a profession are at this point still persuaded that this is a best practice, a way to fight crime. The evidence on that is contrary to their assumption, but they believe it quite powerfully. The federal courts have so far legitimated the practice, accepted it. In the conclusion to the book, we offer some simple guides to where we might go, what we might do if you're concerned about this. One is to begin prohibiting consent-based searches. One of the inducements for doing such a stop is to offer the officer the occasion, the chance to ask for consent to search the vehicle. If you can't do a consent-based search, then there's a lot less incentive to do such a stop. But the other is simply a broad shift in the professional message that the police receive and teach. They now receive and teach the lesson that investigatory stops work, they help fight crime, and they don't really cause much harm. They ought to receive and teach the lesson to each other that investigatory stops cause harm each and every time, and that they don't have a lot of benefits. You stop the wrong people, you search the wrong people, you breed a lot of distrust and resentment in that process. Thank you. I guess if there are questions for either of us or for this, I'm happy to respond as well.
I was just curious, in the research, was there other races that were looked at?
Yeah, thank you for asking that. We had wanted to interview a sample of Hispanic or Latino drivers as well in this community. We didn't. We got a grant to do this from the National Science Foundation, and we were not budgeted enough to do the sample on Latino drivers. And that's one of my main regrets from this study. Yeah, there are a handful of studies that look at that question and find that the disparities between Latinos and whites are about half those as between blacks and whites. Yes.
Did your study take into account parental influence on why an African-American male may drive or not drive in their neighborhood? For example, I would tell my boys, listen, it's just better off if you not. And we taught them that at a young age so that they would have that experience. But I just realized that we were contributing to what you call culture. I'm trying to do it as a good father, so I'll stop.
That is a wonderful question. It's very clear that police practices have consequences for how people, what what they teach their kids. You're exactly right. We didn't, another one of my regrets, a much less big one, is that we didn't ask a question in the survey about that. But we did follow up the survey with people who had been stopped, and we asked them for their stories of stops. And in the course of those stories, many African-American drivers said that they teach their children how to deal with, how to respond to the police in stops, how to avoid being stopped by the police, and so forth. So we found that abundantly clearly. Yeah, you're exactly right. It's that, I have to say though, that's a consequence of a police practice, right? And that's not, you're not saying anything different than that. Yeah, thank you. Other questions? Yeah.
Can you recall what the success rate is for investigative stops? I remember that it's quite low, but can you remember how?
Yeah, so the question is, what is the success rate? It's sometimes called the hit rate. How often, when an officer makes this kind of stop, how often do they find something? The best study on that by far is using the hundreds and hundreds of thousands, over 1 million stops in stop and frisks in New York City. Studies done by Jeff Fagan, and he found hit rates are in the neighborhood of about 1%. You stop 99 people to find something. It's quite remarkable. They're very unsuccessful. The thing is, though, that the police, there's some interesting studies on this. This is how we work. We think you remember the time you found something, not all the times you didn't.
Do you get a sense from your survey how often people deny consent?
Oh, I'm so glad you asked that. So there are other studies on this, and you well may know that most of the time people consent to what an officer asks. We found that as well. Not a single driver that we interviewed said that they declined consent. That's common across these studies, and the reason for it is, and you may know this as well, is that people basically think, well, I know, they would say, I know I could say no, but I actually don't think I really can. So informed consent is a myth. People don't believe that they have power over that they can actually say no and get away with it. They'll say things like, well, if I say no, they'll bring out the dogs, I'll be here for an hour. It'll just go easier if I say yes.
Based in reality, it will be.
Yeah. Yes.
What are the continued justifications you hear for this being a best practice?
Yeah, so the question is, what are the justifications that the police give or tell themselves for why they think this is a best practice? So there's a long answer to that, and I'll try to do a very short version of it. There are a couple studies from the mid-90s that claim to find that deploying this practice reduces crime rates in an area. And one of those is called the Kansas City Gun Experiment. It was done here in Kansas City, Missouri. So you can Google that. It turns out that efforts to replicate those studies have failed since, and so now most scholars in the area believe that this practice is not particularly successful, but the police believe it. But the other thing I have to say is that there are the police professional associations and several federal agencies have conveyed the message for a very long time that it is an effective practice. And they don't provide much evidence for it, but they say, do it, this is how you do it. Train your officers to be polite when they do it, and that no harm will be done. The National Highway Transportation Safety Commission provides this lesson. Look up DDACs, Data-Driven Approaches to Crime and Traffic Safety. The U.S. Department of Justice has favored it at points in the recent past. So there's a large message out there that you ought to do it and that it works. Are there questions in general for the panel?
I don't really have a closing, but thank you for coming. One of the things that came up during the last session, well, what are judges to do? And I'm not sure we have, either one of us has great thoughts on that, since a lot of these are policies and practices. problems. So,
On that, if you have the patience, could I say one thing? It's very clear to us from where we sit that what judges see when cases come to them are the cases where officers found something, where the prosecutor has vetted it and say, yeah, this is a legitimate case, we can prosecute this through. And the judge thus sees somebody who's basically, you know, this is a bad guy, right? What they don't see is all of those other stops where ordinary folks were stopped in this kind of a way. And so the challenge is to place some brakes on the practice when you see the bad guy coming through who's been stopped in this way, arrested in this way, and had some drugs on him or something like that, in order to also protect all those other folks who are completely innocent and deeply harmed by this. And I'm not meaning to weigh in and say we ought to railroad the bad guys through some other way or treat, you know, they have obviously constitutional rights as well. But judges don't see that vast hidden world of folks where nothing was found.
thank you.